And lastly, Your Honor, Mr. Jones, at the time of this incident, was also out on bond from DeKalb County, where he had been charged and eventually, after this incident, pled guilty to marijuana with the intent to distribute felony as well as theft and receiving. And that occurred on October 6th, 2016. And also brings to the court's attention, since being in custody, I have reviewed the jail records for all three defendants. And what I can say to Your Honor is that both Mr. William and Mr. Ott don't have any jail incidents. I cannot say the same for Mr. Jones. He has upwards to what I counted, and to my recollection, 7 jail incidents that include having contraband such as shanks, bones, things of that nature. And he's been in numerous altercations and fights in which he's been cited and through the jail system, guilty, in the sheriff's departments, hearings that they have. So I want to make sure about that to the court's attention as it pertains to how each of the 3 defendants have spent their time as they awaited trial for Bolton County Jail. When the court deems appropriate, Chelsea's mother, Ms. Ambassador, has a couple words she would just like to add to her police of impact statement for the police of these 3 gentlemen.
Okay, but before we get to that, in terms of the sentence breakdown for Mr. Ott and Mr. Williams, it's okay. What was the negotiation?
The negotiation would be as it pertains to the voluntary manslaughter, Your Honor. So count 3 would be a reduction of the voluntary manslaughter 16(5)(2), where it would be 20 years to serve. The remaining felony murder counts that each defendant is charged with would also be reduced, ultimately to be vacated by operation of law. And then the first 2, so counts 12 and count 13 for both Mr. Williams and Mr. Ott would be 15 to serve. At 15 to serve for count 12 would run concurrent with count 3, but the 15 to serve for count 13 would be 15 years consecutive, and then the remaining counts would run concurrent with that consecutive time for a global sentence of 30 years to serve. As to Mr. Jones, the state recommendation is similar, but what it would be is those global sentences would be 15 years to serve to the non-parolable armed robberies. Everything else would run concurrent, Your Honor. So instead of 20 years for the voluntary manslaughter, it'd be 15 years for the voluntary manslaughter for Mr. Jones, and the remaining counts of armed robbery. The life would be 15 years. That's a global sentence.
All right, thank you.
Additional statements. Want to wait for that?
No, she can do it now. Yeah, thank you.
Your Honor, I would just like to say a couple of things while we wrap up here, but when sentencing them, I just hope that you will take into account, like, I will never see this smile again. I won't ever get to hear Chelsea come in my door and say, hey. And it's just my opinion that one time is a mistake. After that, it seems to become a pattern, and I just don't think that it would be beneficial to society to be lenient on any of these defendants, Your Honor. Chelsea gets no leniency. I was shocked, actually, kind of, to think about how I forgot about just how many charges, how many crimes that they did commit. And, you know, I've heard hypotheticals, but hypothetically, if they didn't kill Chelsea, that this would have happened, but they did. They took the life of a human being for $2,700. $2,700 for the life of a human being. She gave him the money. She would have given him jobs. She would have given him anything. And with leniency, they get out, they'll be my age. I mean, I lost my daughter. I'll never get to see her again. I've lived these past 5 years with unimaginable depression, anger, sadness. I've worked so hard on forgiveness. I know that their actions affect so many lives. Down to a story that I heard. I mean, I've heard some stories of people telling me that, you know, your daughter is responsible for where I am today. She gave me a chance when nobody else would take a chance on me. She helped me. She helped me do what I needed to do to move up. She encouraged me to go after my dreams. She helped me. She called the dishwasher and Uber to get him home safely that night. She remained calm in hopes that they wouldn't harm anybody, and she paid for it with her life. I mean, it's because that's the kind of person that she was. She gave you what you needed. She gave you what you asked for. She helped load the money in the bag. You went to that place to commit a crime that ended in the most heinous, the most heart-wrenching of all. Like I said, nobody should ever have to bury their child. Thank you, Your Honor.
Thank you, ma'am.
The state would just ask that you follow the negotiated recommendations from the state's counsel as it pertains to Mr. Williams and Mr. Ott, and we'd ask that you follow the recommendation from the state as it's 15 years non-parole for Mr. Jones. And I don't make that recommendation or ask the court to follow it lightly. I understand that it is a lot of time, but as Ms. Dana just expressed to the court, Chelsea will never get to breathe. She'll never get to walk on this earth again. While in custody, at least Mr. Ott and Mr. Williams have used that time appropriately. They haven't been in any sort of altercation, all being on the same floor as Mr. Jones. So I would point out to the court that Mr. Jones has had the same opportunity as Mr. Ott and Mr. Williams have to show remorse, to show that lessons can be learned even behind custody, or even in custody at the Fulton County Jail. He's proved, Your Honor, that he can, unlike Mr. Williams and Mr. Ott. So I would just ask that the court take that into consideration in the sentencing as it pertains to Mr. Jones. Thank you.
Thank you. All right, we'll start with Mr. Ott. I'll go ahead and have Mr. Hoover, Mr. Ott, come on up to the podium. All right. Mr. Hoover, go ahead.
Yes, Your Honor. Your Honor, Mr. Ott doesn't want to put his family or anyone else's family through anything else. The only reason that it took this long to get to the point to where we can actually resolve this is there were some technical issues that we had to work out with the state and with the co-defendants. With that said, Your Honor, you've heard everything already. You've seen everything already. Mr. Ott is accepting responsibility for his role in what he did in this, and he asked that you take the negotiated plea.
All right. Mr. Ott,
Yes, ma'am.
when the prosecutor was going through all of your rights, were there any that you were confused about or you didn't understand that you want me to go through again with you?
No, ma'am.
So you fully understand all the rights you are giving up by pleading guilty today?
Yes, ma'am.
Is anyone forcing you or pressuring you in any way to plead guilty?
No, ma'am.
And are you pleading guilty to 7 counts of voluntary manslaughter, 2 counts of armed robbery, 5 counts of aggravated assault, 1 count of kidnapping, 5 counts of false imprisonment, 1 count of burglary in the second degree, 1 count of smash and grab burglary, 1 count of hindering an emergency telephone call, 1 count of hijacking a motor vehicle, and additional count of armed robbery and aggravated assault because you are in fact guilty of those crimes.
Yes, ma'am.
All right, Mr. Ott, the court finds that you understand the nature of the crimes and the consequences of your guilty plea, that there's a factual basis for your plea and that your plea is being made knowingly, intelligently, and voluntarily. As stated by your counsel, you are up here taking responsibility for your actions in these crimes that led to not only Ms. Beller's death, but to the crimes upon the other victims and the impact that they have suffered. Because you are taking responsibility for that, I am willing to follow the negotiated sentence. As to count 3, felony murder reduced to voluntary manslaughter, I will sentence you to 20 years to serve. Counts 4, 5, 6, 7, 8, and 11 will vacate by operation of law. For count 12, armed robbery, I will sentence you to 15 years to serve concurrent with count 3. Count 13, armed robbery, I will sentence you to 15 years to serve consecutive to count 3 and the other counts. As to counts 14, 15, 16, 17, and 18, aggravated assault, I will sentence you to 20 years to serve concurrent with count 3. Count 19, 20 years to serve concurrent with 19. Count 20 will merge into count 19 for the purpose of sentencing. Count 21, 22, 23, and 24, 10 years to serve concurrent with count 3. Count 25, 5 years to serve concurrent with 3. Count 26, 20 years to serve concurrent with 3. Count 27, 12 months to serve concurrent with 3. Count 28, 20 years to serve concurrent with 3. Count 29, 20 years to serve concurrent with 15 years to serve, I'm sorry, on count 29, 15 years to serve concurrent with count 3, and count 30, 20 years to serve concurrent with count 3, for a total sentence of 30 years to serve. Do you understand the sentence?
Yes, ma'am.
I apologize, I misspoke. So as to count 3, it should be 15 years. I just did the math, and lawyers are terribly bad at math, so that would equal to 35 years. So it counts 3 and count 26 would additionally both be 15, and that would be a total of 30 years to serve. So I apologize, Judge.
I was just about to say that.
So all the counts I just announced 20 years on, the sentence will actually be 15 years. So for all the aggravated assault counts, the kidnapping, count 3, voluntary manslaughter,
And count 26, the smash and grab burglary.
and count 26, a smash and grab burglary. All right. So that's fine. All right. Do you understand that sentence?
Yes, ma'am.
Okay. All right, Mr. Ott, as I said, you are accepting responsibility. I have a long time in prison to think about this, but it is the court's hope that when you are eventually released, that you will have learned from your mistakes, that you will have made the decision to make better choices in your life, and you will move on to be a productive member of our society when you do return, in the event you are released. All right, thank you.
Thank you, Your Honor.
Mr. Williams. All right, Mr. Francis, go ahead.
Thank you, Judge. Good morning. Likewise, we're accepting responsibility. We're asking that court accept the plea as negotiated between my client and the state.
All right, Mr. Williams. When the prosecutor was going through all your rights, were there any that you were confused about or you didn't understand that you want me to go through again with you?
No, ma'am.
So you fully understand all the rights that you are giving up by pleading guilty today?
Yes, ma'am.
Speak clearly.
Is anyone forcing you or pressuring you in any way to plead guilty?
No, ma'am.
Are you pleading guilty to 6 counts of felony murder, 2 counts of armed robbery, 5 counts of aggravated assault, 1 count of kidnapping, 5 counts of false imprisonment, 1 count of burglary in the 2nd degree, 1 count of smash and grab burglary, 1 count of hindering a person from making an emergency phone call, 1 count of hijacking a motor vehicle, and an additional count of armed robbery and aggravated assault because you are in fact guilty of those crimes.
Yes, ma'am.
All right, Mr. Williams, the court finds that you understand the nature of the crimes and the consequences of your guilty plea, that there's a factual basis for your plea and that your plea is being made knowingly, intelligently, and voluntarily because you are willing to accept responsibility and admit your guilt. In this case, the court will follow the recommended sentence reached between your attorney and the state. As to count 3, felony murder reduced to voluntary manslaughter, will sentence you to 15 years to serve. 4, 5, 6, 7, and 8 will be vacated by operation of law. Count 12, 15 years to serve concurrent with 3. 13, 15 years to serve consecutive to count 3. Counts 14, 15, 16, 17, and 18, 15 years to serve concurrent with 3. Count 19 as reduced, 15 years to serve concurrent with count 3. Counts 20, 21, 22, 23, and 24, 10 years to serve concurrent with 3. Count 25, 5 years to serve concurrent with 3. Count 26, 15 years to serve concurrent with 3. 27, 12 months to serve concurrent with 3. 28, 15 years to serve concurrent with 3. 29, 15 years to serve concurrent with 3, and count 30, 15 years to serve concurrent with 3. Do you understand the sentence?
Yes, ma'am.
All right, Mr. Williams, same announcement I give your co-defendants. I hope you use every single day of these 30 years to think about what you've done, to continue to have remorse, and to make that decision that when you do re-enter society, that you will be a productive member. All right, thank you, Mr. Williams.
Thank you.
Mr. Jones. Do you break? No. All right, Ms. Cochran.
So today, Your Honor, Mr. Jones is taking responsibility. I know this case has been open for 5 years, and I can't apologize to the victim's family, all the victims, enough that it took this long to get to this point. As Your Honor has heard through the factual basis, Mr. Jones is a party to these crimes. He's pleading as a party to these crimes, having dropped the 3 co-defendants off. You know, he's taking a plea that's going to affect, you know, he has a conviction, convictions the rest of his life for armed robbery and kidnapping, having never, you know, held a gun to somebody's head and demanded money. And he isn't accused of planning this or supplying any of the tools that were used in committing these armed robberies. I don't think at the time he could have ever imagined. And, you know, he's obviously, we've been talking about it a lot since he's been incarcerated, what had happened after they got out of his car. Just truly like the most horrific thing ever. And so, Your Honor, he wants to take responsibility, and what I'm asking the court to do is to take into consideration the lack of violence that he personally was involved in. And I know that Mr. Abadi mentioned things that have happened within the Fulton County Jail. I haven't received those reports. However, I have many clients in that jail. I've had clients die in that jail in the past 5 years. I've had clients stabbed in that jail. And what I can tell you is it's really not I'm hoping that prison is a better place to be corrected and rehabilitated. But what I can tell you is that in that Fulton County Jail, where he's been housed with the people he's been housed with in 4-person cells, they charge them all with an offense because it's really not safe for them to tell on each other. Respectfully, that same situation is what has possibly caused the delay here and why we hadn't taken a plea sooner. Mr. Jones is 24 years old. His mother is here. He has younger siblings, they're twins. It's their birthday today. And he is just asking this court for mercy. I know Mr. Abadi said that he doesn't believe that based on how he's acted in the jail, that he's not taking it seriously or that he isn't going to be rehabilitated. But what I can tell you is I've had tons of clients, Your Honor. I've pled clients to 30 years. I've had clients taking life pleas. It's personal at this point for me that I really do believe in Mr. Jones. I believe in his ability to do better, that he won't cause any sort of violence towards anybody in the future. He understands what happened because he dropped them off. And he has to live with that. And he's going to be an armed robber the rest of his life. I understand party to a crime. I would ask Your Honor, and I know that it's 15 years to serve. If Your Honor would consider, 15 years to serve 10 of those years, I wouldn't mind him on probation for a few years with 200 hours of community service every year that he's on probation. Something productive so that he can get back into society and give. One of the issues that I have with prison is that it's a place where I feel like it's very difficult to be productive. We pay for them to sit there and not do that much. I would love him to be instructed by Your Honor as special conditions to do community service every year that he's on probation. I wish he could do it while he's in the jail or the prison, but he can't. We're very remorseful. It's a horrible situation. Definitely did not want to put the families or the witnesses or the victims through a trial. We're just asking for fairness and individual consideration as it relates to Mr. Jones. And I know that's been hard because we all know what happened after he dropped them off. So it's hard to look back and not think, how did you not stop them? Or, but we know what happened. So in that moment, he didn't, but he knows now. Thank you, Your Honor.
Thank you. Mr. Jones, when the prosecutor was going through all of your rights, were there any that you were confused about or you didn't understand that you want me to go through again with you?
No, Your Honor.
So you fully understand all the rights you are giving up by pleading guilty today?
Yes, Your Honor.
Is anyone forcing you or pressuring you in any way to plead guilty?
No, Your Honor.
And are you pleading guilty to 6 counts of voluntary manslaughter, 2 counts of armed robbery, 5 counts of aggravated assault, 1 count of kidnapping as reduced. 5 counts of false imprisonment, 1 count of burglary in the 2nd degree, 1 count of smash and grab, and 1 count of smash and grab burglary, because you are in fact guilty of those crimes.
Yes, Your Honor.
All right, Mr. Jones, the court finds that you understand the nature of the crimes and the consequences of your guilty plea, that there's a factual basis for your plea, and that your plea is being made knowingly, intelligently, and voluntarily. I understand that you are up here accepting responsibility and expressing remorse through your attorney.
Yes, Your Honor.
Your argument is that you just dropped your co-defendants off, and that was the end of the story, but that's not what the factual basis reflects. The factual basis reflects, yes, go ahead.
On that note, so I forgot, are you talking about how he went back with them
Yes.
later? Okay, perfect, because that was something I wanted to mention to Your Honor. Terry Jones does not have his own car. Terry Jones had actually dropped them off in one of the co-defendants' cars. It wasn't his to keep. He had to meet back up with them later to give him his car back. Otherwise, he'd be, I guess, in receipt of a car that did not belong to him. So he did meet back up with them later. It wasn't his car. And so he did have to meet them to give the car back. And I know that Mr. Abadi also mentioned that they split the proceeds. And I don't believe that there is a factual basis for, and I can tell Your Honor that at a trial, I don't believe that any evidence would come out that he received any more than the other person that drove them.
Mr. Abadi?
That's incorrect.
Okay. Can you lay the factual basis of what state's evidence you anticipate would show with regard to Mr. Jones receiving proceeds that were obtained during these crimes?
Yes, Your Honor. And speaking with Dante Furlow, after driving or picking up Mr. Bailey, and unbeknownst to him, it would be Mr. Ott, Mr. Williams who would get to his vehicle. He drove back to his house, also in DeKalb County. When he got to his house, the 3 co-defendants went with him into his basement. They were waiting, or excuse me, garage. They were waiting for Mr. Jones, who had been in contact with Mr. Bailey, to come to Mr. Furlow's house. Mr. Furlow would testify that the defendants did not begin to count the money until Mr. Jones arrived. So the money did not come out of the bag in which they stole from Chelsea Beller after they shot and killed her until Mr. Jones arrived. When Mr. Jones arrived was when the money began to be counted and split up between the 3 co-defendants. I further informed the court.
You mean 4?
There's 4
Excuse me, 4 co-defendants. I further informed the court that after this incident, when there was a slew of news that occurred pertaining to the murder of Chelsea Beller, Mr. Jones went to Las Vegas and spent what the state would contend his proceeds. And I understand counsel's argument would be that Mr. Jones had the trip planned prior to his involvement in the death of Mr. Beller, and I don't disagree. But after he found out what ultimately he was the vehicle or the avenue that actually brought the guns, the armed gunman to the Barcelona wine bar that ended the life of Chelsea Beller, he never went to the police. He never contacted anyone in law enforcement. And in fact, he went to Las Vegas to enjoy his brother's birthday while the family of Chelsea and the 4 victims whose lives who have been forever changed, who are no longer productive members of society because of the actions that this defendant participated in that led to them being held at gunpoint, them being, their hands and feet being taped behind their back as 2 individuals pointed loaded handguns at their heads, praying that they didn't die. The dishwasher, Mr. Johnson, because of Miss Beller's death, has condemned himself to living the worst possible life. He doesn't commit crime. He doesn't do anything with anyone. He's become a recluse. He has chosen, instead of living in a house or in a home, to live on the streets because he feels that guilty. Because Miss Beller had called the Uber for him. Because as I've run through my involvement with this case, the most important person to work at a restaurant is the dishwasher. Without the dishwasher, nothing can go on. So what Mr. Ferrero explained to me, that it's not uncommon, in fact, it's very common, that the manager, assistant manager